Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more.
Yeah, Tom Gresham. He's not here. It's Ryan Gresham. You've got me today. I'm guest hosting for Tom, but he'll be back next week. Don't worry. Don't worry. You only have to put up with me for, a little while longer. So we've been talking today on the show about what is happening in the world of gun rights, and we are beating them back. We are winning. And one of the super battleground states, of course, is California. And one of the freedom warriors out there is Chuck Michel. Chuck, welcome to the show, and thanks for being on.
My pleasure. I'm happy to put up with you.
That's right. We appreciate it. So, Chuck, you're a Second Amendment lawyer in California, kind of operating behind enemy lines over there. Talk about what's been going on with the Ninth Circuit and the Duncan case.
Sure. Well, it's my pleasure to be on the show. I'm also the president of the California Rifle and Pistol Association as a volunteer. And the CRPA has been very active in filing lawsuits, as have some other groups, challenging both before the Bruen decision, that wonderful decision from the Supreme Court that actually gave the Second Amendment back some teeth, and now after. And the Duncan case is a great example of one of the things that CRPA has been doing. But there's a dozen other cases. But the Duncan is very high profile because it actually we filed a challenge to the state's ban on the possession of magazines that can hold over 10 rounds. These are standard capacity magazines that the state likes to call large capacity magazines.
Right.
We won in the district court in front of Judge Benitez, who we all at this point have come to know and love because he's been getting it. He kind of understood the problems with a state that can ban or severely restrict firearms on civilians, and has been wonderful in following, being faithful to the Heller case, and now he's going to have to rule again on several cases as a result of the Bruen decision. So the Duncan case was litigated in front of him. He struck down the state's ban on possession of or importation or sale of magazines that hold over 10 rounds. The state naturally immediately appealed, went to the Ninth Circuit. The Ninth Circuit, even though it's typically been hostile to gun rights, and when I say hostile, I mean for 14 years since Heller came down in 2008, the Ninth Circuit has been bending over backwards intellectually to try and uphold gun control laws, even no matter how ill-conceived or useless,
right,
or unconstitutional. But lo and behold, we actually won in front of a 3-judge panel in the Ninth Circuit. That's because Trump has changed the composition of the Ninth Circuit so that it's not. It used to be about 1/3 Republican, 2/3 Democratic appointees, so it's been a notoriously liberal circuit. Now it's about 50-50. So we got a couple good judges. We won in front of the 3-judge panel. The standard capacity magazine was struck down, but as the Ninth Circuit is apt to do, the liberal judges on the Ninth Circuit anyway, they took that up to an en banc panel, which is basically an appeal of the appeal. You go from the 3-judge panel to an 11-judge panel. And that 11-judge panel overturned both the district court and the 3-judge panel's victory and said that the magazine capacity ban was constitutional. So we asked the Supreme Court to review that decision. The Supreme Court was in the process of getting ready to rule on the Bruen decision, so it held the Duncan case and 3 other cases sort of in limbo until after it ruled on Bruen. And then when it ruled on Bruen, it took those 4 cases, it accepted them for review, but then didn't require briefing. It just is called a GVR, grant, vacate, and remand. It granted review and without argument just vacated the lower court's opinion. So it vacated the en banc panel and then remanded it back to the en banc panel saying basically, reconsider this in light of what we just said in Bruen. We just got word 2 days ago that the en banc panel, rather than considering it directly, and there was some heated dissents, I should say, amongst the en banc panel members, that said we should just decide this right now. Well, rather than decide it right now, they remanded it back to the district court again.
It gets sent back down to Judge Benitez, who has already ruled the ban unconstitutional. So now what?
Please don't throw me in the briar patch.
Yes, that's right. Absolutely.
So the only
now
bad
what,
thing
Chuck?
is it's going to take a while. Well, we have to. The judge will order. This, by the way, is sort of become the norm of all the courts of appeal that had a Second Amendment case pending. They're all remanding them back down to the district court because the states are begging for an opportunity to try and go out and find some kind of historical analogous law that they can argue anew in the district court justifies the laws that they're passing. But they're not going to find any kind of a magazine capacity limitation in history. They're going to have to really stretch. I mean, they're looking at 18th century mousetrap laws and trying to say, oh yeah, this applies to guns. I mean, that's how desperate they are. But some judges may buy it. I just don't think Justice Benitez is. So we'll have to submit supplemental briefs, and I expect Judge Benitez will once again strike down this law because after all, this is a higher test than he originally applied, a stricter test. And he considered the history because he knew, judges that were paying attention knew where things were going, knew that originalism was going to be the new approach to evaluating the constitutionality of a gun control law. And so he applied it, the first time around. Mm-hmm. So I think that it's safe to say, I don't want to say this because it'll jinx me, but the odds are good that the state California's magazine capacity limitation law is going to be struck down, along with several other laws like the Assault Weapon Control Act and the ammunition background check law. We have Kim Rohde, who we all know and love, leading the plaintiffs group on that one.
Right.
And they all go back to Judge Benitez. So,
wow.
I will be seeking a new injunction in front of Judge Benitez soon. But folks should be aware of one thing. Gavin Newsom, in his sinister little effort to try and stop us from being able to challenge all the state's laws, passed a law that makes it impossible to recover attorney's fees and subjects the lawyers and the plaintiffs to potentially having to pay the state's attorney's fees. So,
but just special to gun cases, right?
Only gun cases.
He's singling this out. Oh my
goodness. Which is
goodness.
outrageous. And he modeled it after the Texas law, which, I'm not advocating a position one way or another on abortion, but Texas passed a law that said that anybody challenges an abortion ban can't recover fees, and Newsom basically copied it. So, we're suffering from the fact that Texas passed this and the Supreme Court didn't overturn it immediately, but he's made it into as if the Supreme Court ruled on it. They didn't. They just said, we're not going to grant an injunction on this. You got to go back down to the lower court and work your way back up again. So instead, we have to file a challenge to this prevailing party, the rules changes for prevailing parties before we can really get back in there and fight all these other cases. So we got to get back on the field to move the ball downfield before we can start playing that game again. In the meantime, we have to get this obstacle out of the way.
Well, and obviously this is impacted by the decision in Bruen. How does this suggest we're going to see other gun laws reversed by Bruen? I mean, where does this go?
Well, it's become, to be honest with you, it's become sort of a battle of experts. We used to have a battle of experts about gun policy. Does a gun control law work? They never work, but that doesn't mean that the states can't find experts that say they do. So that was a battle, like an empirical battle about evidence, about statistics. Now and they always had junk science. Now they're going to have junk history. They're pulling out these historical analogies, trying to say that these very convoluted laws are proof that the founders would tolerate a ban on magazines that hold 10 rounds, or a background check on ammunition, or a ban on certain semi-automatic firearms.
Yeah,
it's just
Chuck,
not going to fly. We're going to see a lot of things change.
Chuck, you guys are fighting the good fight. This is excellent news, and it's be interesting to see what happens with these other magazine bans in other states or magazine restrictions. Fact of the matter is, this Bruen case has changed everything for gun rights, but we got to fight and to win back these rights. Chuck, thanks for being on with us. We will be back
anytime.
Yes, sir.